Also, Ms. Treichler has indicated that she is ceding her time on the public safety issue to gas-free Seneca. So I've changed that to gas-free Seneca will have 20 minutes on the public safety issue. And Ms. Treichler will not be hearing on that issue. So are we ready?
Yes, Your Honor, my colleague Manine Naismith will be presenting.
We're back on the record.
Thank you, Your Honor. I'd like to reserve 5 minutes of my time for rebuttal, please. Sure. Thank you, Your Honor. I'd like to begin by saying that, emphasizing that while community character is a very important issue to the petitioners, we also have multiple other important issues that we'd like to discuss and that we think are of grave concern warranting an adjudicatory hearing. One of them is the public safety implications of this project. Gas-Free Seneca has presented a substantive and significant issue regarding the potential risks the project poses to the surrounding community. The operation of the facility presents risks from the storage of LPG in the salt caverns, as well as the transportation of the LPG to and from the facility. In support of that position, Gas-Free Seneca, with its petition for full party status, submitted a quantitative risk analysis by Dr. Rob McKenzie, which concluded that while not all the risks posed by the facility were high, the potential consequences were sufficiently severe that additional investigation is required. This reality is only underscored by the voluminous submissions the applicant submitted Monday evening, which, although purport to dismiss Gas-Free Seneca's concerns, actually reinforce that there is a large amount of information relating to the risks of this project that have yet to be the subject of very much public or even department review. As a result, this issue is a substantive one in that there is sufficient doubt as to the ability of the applicant to meet the requirements under SECRA to avoid or minimize adverse impacts to the extent practicable, and reasonable inquiry is required in order to resolve this doubt. This is also a significant issue because proper consideration of risks posed by the project could result in the denial of a permit under SECRA, or major modification of the project, or potentially additional conditions on top of those already in the draft permit. The applicant has attempted... Sure.
Quickly. So these are purely secret issues. There's no ECL standards that apply with respect to this issue as far as you're concerned?
This issue is a bit of a broader one, sir, insofar as it does cover cavern integrity issues and some of the salinity issues we'll be talking about later today, and those absolutely implicate the ECL. So to the extent that we're talking about those risks, they do implicate the ECL as well as SECRA. This is the consideration
of risks driven by the cavern integrity requirement of the environmental conservation law.
Yes.
It does.
Yes.
So it's not just secret.
It's not just secret.
All right.
Thank you. The applicant has attempted to distract from the importance of this topic by attacking Dr. McKenzie's qualifications to act as an expert in this area. These contentions are not supported by the facts here, are contradicted by the applicant in its own submissions, and are not supported by New York law. Experts can be qualified based on academic credentials or training, but they also can be qualified based on job experience. Just as Finger Lakes wishes to use an expert, Mr. Istvan, I apologize if I'm not pronouncing that correctly, who has no advanced degree and a BA only in geology, but he has many years of experience working for Crestwood, and therefore his opinion is relevant, according to the applicant, to their submissions. Dr. McKenzie similarly has extensive on-the-job experience as, in this case, a medical doctor and CEO whose responsibilities include conducting risk analyses and prioritizing, managing, and mitigating risks. In fact, his experience is sufficiently extensive that other CEOs have asked him to come and train them in how to manage risks at their facilities. In addition, the case law that the applicant cites in no way supports their contention that Dr. McKenzie's report should be ignored. In fact, none of the cases they cite even bear on the actual question of what constitutes a qualified expert. At best, they stand for the general proposition that you need a qualified expert, but do not delve into the details of why exactly they think Dr. McKenzie should be eliminated from consideration here. Dr. McKenzie is a qualified expert in risk analysis. He has 10 years of on-the-job experience, and his opinion should be given full consideration. I also wanted to quickly address the point that the DEC has made, and as well the applicant has made in their submission, which is to say that the risk posed by rail and pipelines should be ignored because somehow the DEC is preempted from consideration of those issues. Federal preemption in this area applies to the state's inability, or is defined as the state's inability to regulate the railway or the pipeline. No one is suggesting that the pipelines or the railway be regulated here. What we are suggesting is that as part of the DEC's mandate under SECRA to review the project, the LPG storage project, which no one disputes it has full jurisdiction to permit, they need to consider the risks that would be caused but for this project, which do involve the operation of the railway and the pipeline. The case law they support is, again, about the regulation of a railway, not the evaluation of the risks associated with a project that happened to involve the railway. And in fact, the governor of this state recently asked DEC to conduct a risk assessment of crude by rail in this state, and there didn't seem to be any preemption problem there. The preemption issue exists with respect to the possible mitigation measures, but the fact that these risks may not be mitigated does not obviate the department's responsibility to consider those risks as part of their secret determination. And we are happy to brief that issue for you more fully after this conference if you would like. Turning back to the actual risk assessment here, the 100-page submission that Finger Lakes put into the record on Monday contains a quantitative risk analysis complete with exhibits and purports to analyze the transportation risks associated with the project, although the applicant also claims that those risks don't need to be analyzed and that the record was sufficient before this submission. If you compare the Quest report that was recently submitted and Dr. McKenzie's report, what you end up with is two experts employing different methodologies, different calculations, and different assumptions. Quest's report does not negate the findings in Dr. McKenzie's submission. It presents only an alternative manner to evaluate some of the risks posed by the project. There is, in essence, a disputed issue of fact as to how to calculate the risk, which is exactly the type of question that should move on to an adjudicatory hearing. Dr. McKenzie's methodology is to conduct a top-down analysis looking at where there have been serious incidents relating to hydrocarbon storage in salt caverns. He calculates all-cause actual historic death and injury rates based on reputable sources such as the federal government's Pipeline Hazardous and Safety Management Authority. Quest's analysis takes a different tact and focuses on theoretical predictions about the equipment rather than analysis of historical incidents. There are limitations to Quest's general approach. For example, the Quest risk analysis would not take into account an accident that occurred at an energy property years ago, Energy being the predecessor to Crestwood, where there is storage in Bath, New York of LPG in salt caverns and where there was an accident and a fire and 4 injuries. The calculations in the Quest versus Dr. McKenzie report are simply done differently, and there are questions about selection of data points, which further underscores the need for additional inquiry into the methodologies used and the results arrived at. For example, McKenzie looks at the risk associated with all the pipeline in Schuyler County that would be used to feed this project, whereas Quest looks only at half a mile of pipeline that would be installed on the actual facility site. Quest's numbers also don't include past accidents in the US, where there were actually a larger number of accidents over the time period Quest is examining. McKenzie looks at worldwide figures. Quest selected only European figures, which were much lower at the time. If Quest had used the number for US accidents, their figure would have been 20 times higher. Quest also looks at accidents per cavern instead of accidents per facility, so you have a larger number of caverns and therefore the risk number you end up with is lower by virtue of just dividing by a larger number. McKenzie uses the facility. Quest also looks at accidents per cavern rather than accidents per, I mentioned that. They also look only at accidents involving the loss of the cavern for storage purposes, and whereas McKenzie looks at all serious accidents even if the cavern was then later repurposed and used for future storage. The conflicting calculations from these two experts clearly show there's a need for an adjudicatory hearing to further develop the record and arrive at a comprehensive understanding of the risk of this project. The risk of serious accidents from storing LPG in salt caverns are real. As I mentioned, there was an accident at the energy site. There have been other accidents, such as the one in Hutchinson, Kansas, where gas stored in an underground salt cavern escaped the cavern and caused significant damage in a town, as well as a couple of deaths and other casualties. Again, the bottom line here is storing hydrocarbons in salt caverns poses a significantly greater risk than storing it elsewhere. Transporting LPG also creates the potential for serious accidents involving death, injury, or the need for substantial evacuation. An adjudicatory hearing is required in this instance to allow for further inquiry, resolve which approach comparing Mackenzie's versus Quest should be taken, and ultimately coming up with a calculation that would form the basis for the department to conclude one way or the other whether the risks posed by this project to the community are acceptable. The question here therefore presents a substantive and significant issue and provides a basis for Gas for Seneca to be accorded full party status. I'm happy to answer any questions you may have.
So I just want to make sure I'm clear. Your proposal then would be to essentially complete the secret record by adjudicating your risk analysis in an adjudicatory hearing.
That's correct.
You're not simply arguing because they haven't done the analysis that you think they should, that we should deny at this point and be done.
Well, I think, Your Honor, that there are certain pieces of the analysis that they have failed to do, which may, especially with respect to the salt cavern integrity questions that we'll be discussing later this afternoon, that would argue for the denial of the permit. At a minimum, we would say that given the conflicting expert reports that we have on the overall risk when you factor in all the components of the project, that there are real questions of fact here, and that those need to be, the record needs to be further developed. There needs to be further inquiry as to which numbers you should use, what assumptions should be used in this calculation to determine what the actual risk is posed by the entire facility, in addition to the cavern integrity and the transport as well.
And assuming that you put off a record on these additional risks, then would you be proposing some additional mitigation, or what at that point would be the outcome?
It would depend on the risk that we would be addressing in that case. I think there's some mitigation measures might be appropriate. There might also be some discussion of modifying the project, especially with respect to cavern integrity. But as there also might be the reality that some of these risks cannot be mitigated. Well, again, the risks of rail and pipeline transportation may be such that there are no mitigation measures that can be proposed, and as well as some of the risks posed by storing the LPG in the salt cavern may be sufficient that we cannot mitigate them in this case, that these caverns are inappropriate for storage and therefore the permit should be denied.
All right.
Thank you.
So you'll have another 5 minutes in rebuttal.
Thank you. Seneca Lakes communities. Are you reserving any time?
Yeah, I'll reserve 3 minutes, Your Honor, but I don't expect to take the full 7 now, subject to whatever questions you might have, of course. Again, I'm Kate Sinding. The Seneca Lake communities are deeply concerned about the ability of emergency personnel and first responders to address an accident, especially a catastrophic one, at the proposed facility. They are, moreover, deeply concerned that the risks of such an incident have been completely inadequately considered by the applicant in the application, DEIS, and accompanying materials, and in turn by the department. They've raised a substantive and significant issue with respect to public safety in this regard. The communities proffer the testimony of Richard B. Kuprowitz that the quantitative risk assessments conducted on behalf of the applicant are sorely deficient and fail to identify the real potential for significant adverse impacts from a catastrophic failure at the facility. Mr. Kuprowitz's qualifications are detailed in his affidavit sworn to on January 15th and submitted in support of our petition for full party status. Mr. Kuprowitz is widely recognized as a national expert on hydrocarbon infrastructure risk management, spanning a 40-year career, serving on both federal and state advisory bodies concerning pipeline safety. Due to the very late date of NRDC's retention in this matter and by extension, that of Mr. Kuprowitz, he was unable to prepare a detailed report for submission in support of the petition, but he was able to submit a brief affidavit on the basis of his review of the relevant materials. Based on that review, Mr. Kuprowitz is highly concerned that the proposal to store extremely large amounts of liquefied gas in underground caverns, as much as 2.1 million barrels between the two caverns, presents extraordinary risks and ones that have been inadequately considered by the applicant or the department. At an adjudicatory hearing, Mr. Kuprowitz is prepared to testify as to the outside risks presented by LPC storage in large volumes in underground caverns, as well as the astronomical costs that would be associated with responding to a catastrophic release of LPG from one or both caverns. And that's something that, of course, will come up again tomorrow when we discuss the indemnification clause. To anticipate or respond to one of the questions that you directed to Ms. Naismith, based on our discussions with Mr. Kuprowitz, I believe that he would testify that it is essentially an unmitigatable risk. It is Mr. Kuprowitz's opinion that it is a common fallacy to dismiss so-called low probability events with serious potential consequences, a fallacy that the applicant has committed here. He would testify regarding the potential for a series of failures along a chain of linked events to actually drive the system to catastrophic failure with much greater probability than that associated with each individual event. In other words, he would testify that it's necessary to consider the cumulative risk presented by a number of potential failures along a chain, and that although the risk associated with each one of those might be small, together they could lead to a catastrophic event at a much higher rate of probability. And that is something that is not, an analysis that has not been undertaken here. Thank you.
All right, so he would not be presenting any evidence on potential mitigation of these risks then?
I believe,
based on your view that, or his view that they're unmitigatable risks.
I believe that he might be able to speak to what mitigation is conceivably available. I believe that it is his opinion, though, ultimately, that the risk is so great here that, that those mitigation measures are inadequate.
All right, I have no questions.
Thank you.
The Finger Lakes wine business? Are you reserving any time?
Yes, please, Your Honor. We'd like to reserve 4 minutes.
4 minutes?
Thank you. Again, Your Honor, we present the position of the Finger Lake Wine Business Coalition, and we feel that in terms of the risks that have been identified as landowners, adjoining landowners, business owners, and members of the public, we face potential for injury from the applicant's project, and that injury falls squarely within the zone of interest protected by the statutes of DEC. We feel that the DECIS fails to address the potential impact of a catastrophic event. It fails to provide sufficient information regarding indemnification to the surrounding community as a consequence of the event, and fails to adequately address the irreversible and irretrievable commitment of resources to the project by the local community. The draft permit currently fails to provide conditions that are sufficient to protect the surrounding community from the potential damages of a catastrophic event. It fails to identify or mitigate the potential harmful impacts of gas storage so as to adequately protect health and human safety, and particularly the agricultural uses that are unique to my clients. The vineyards themselves take years to develop. This is not something that is an instantaneous product. There's years that go into developing the vines and then the harvest themselves. In the event of a catastrophic event, my clients and their interests would be uniquely damaged. They would not be able to recover from a catastrophic event that impacted either the water or the lands themselves. So we would submit that the petition, our petition raises issues that fall squarely within those issues that need to be considered under SECRA. SECRA requires that an agency approving an action must make findings regarding the agency's consideration of the environmental effects, alternative actions, and the minimization or avoidance of adverse environmental impacts. It's our opinion that the impacts upon the agricultural community, the vineyard community, have not been considered at all. Finally, the draft permit conditions do not adequately protect health and human safety or the impacts upon health and human safety for crops and animals that may be subject to exposure from fire, from explosion, or from the slow escape of gas. Draft permit condition 7 provides that the applicant must install certain shutdown devices at the LPG facility. We submit that there's no consideration of those shutdown considerations for the agricultural impacts. Additionally, condition 8 requires reporting of certain non-routine incidents to the DEC. It does not identify what those non-routine incidents are or the impact on the well-being of the community. No sufficient inquiry has been made to determine the scope of potential damages which may arise from either an explosion or a fire or from the slow release of gas, and the reliance of the public services in the community and the volunteer emergency services would be woefully inadequate in the event of a catastrophic event. This is a substantive issue that needs to be identified and examined in the context of an adjudicatory hearing, and we need to examine proposed mitigation measures in relying upon the local volunteer fire and EMT services, since these services are insufficient to deal with any type of catastrophic event. The issue raised by the petitioner is significant because if the applicant is unable to comply with the proper health and safety requirements or to assume the obligations that arise from that, then they fail to meet the requirements for approval of the draft permit.
So again, you've applied for amicus status.
Yes,
So
Your Honor.
to the extent that it's your view that they're inadequate, that the draft EIS inadequately addresses some of these issues, how as an amicus would you be filling those gaps since you wouldn't be seeking to provide any testimony or expert testimony on the issue?
It's not expert testimony, Your Honor, but our perspective and the legal issues as far as whether or not they've sufficiently met the requirements, both under seeker and under the permit conditions, our voice should be heard in that regard, and we think that it does provide input to the court.
So for example, you argue that there'd be an impact on local emergency response that hasn't been analyzed, but you're not proposing to make that analysis, correct?
No, we are not proposing to make that analysis, but we do propose that under the statutory requirements, the applicant is required to make that analysis, and that analysis has not been presented to you.
What particular expertise do your clients have to provide argument on these risk issues?
I don't think under the statute we're required to show that we have particular expertise, but that we have an environmental interest. And I think that we do have an environmental interest as a member of the community, the businesses that serve that community, the tourists that come to that community, that they too will be impacted in the event of a catastrophic event and the applicant's failure to meet those public safety issues.
All right, thank you very much.
Thank you.
All right, so legislators Harp and LaSalle. Are you reserving any time?
Yes, we'd like to reserve 2 minutes for rebuttal, and I will share the time with my colleague, Mr. Harp.
All right, well, you don't each have 10 minutes, right?
No,
Okay.
4 minutes each. We filed our amicus brief as 2 county legislators to ensure that certain issues are adequately brought forward before the DEC. As our petition states, the first issue is the geography of our county, particularly the Glen and the Watkins Glen State Park, which the trestle that passes through that park would be transporting tankers full of LPG. The Watkins Glen State Park is the second most visited state park in the state. Just last week, the headline in our county was that 700,000 people were in the park last year. Now, the geography of the park is a very steep, narrow gorge, so that if a significant number of tourists were in there and there was an accident, there would be no escape. When you, given for the time that the park is closed, there's about 3,000 people in there every day. So this is an issue that we feel is proper to be before the issues conference. In the decision I cited in EXO, it was found to be proper to decide whether gas would be delivered by rail or by pipeline. And I would again repeat what others have said, that sure, once the gas is being transported over the track, that is federal jurisdiction, but that the DEC would have authority to deny the permit or modify it if they thought that the danger, particularly to a park that is also administered by the DEC, would be affected. The other issue that we bring forward is the adequacy of our local comprehensive emergency management plan. And to be quite clear about this, I would say that our county legislature is in something of disarray when it comes to this issue. We filed our petition on January 16th, and 10 days later, our emergency management officer had our draft plan ready for review. At the next Wednesday's legislative review meeting, we discussed it. Now, I will mention that along with not addressing the Axel decision, the response talks about the ratings of certain hazards, but it uses our 2008 plan. In this plan, a hazmat accident in transit on the HAZNY scale of 0 to 400 was rated 276. A terrorism incident was rated at 279. At our Legislative Review Committee meeting, I asked why all of a sudden was a hazmat release in transit lowered to 166 and a terrorism incident to 188. Keep in mind that Watkins Glen, with the Watkins Glen International Racetrack and the mass gatherings that occur there, is referred to as the number 2 site for terrorism attacks outside of New York City. So, even with those discussions, it was left on the agenda for last Monday's legislative session. And at that point, the chair of the legislature asked that it be withdrawn for consideration, tabled, so that we could take a few months to really review this plan. And that is our big concern, that if this facility is approved, that Schuyler County have a plan that will adequately address the dangers that will be coming into the county. Legislator Harp and myself have taken different steps over the year, and I think that our brief adequately sets that out. But our primary concern is that Schuyler County have an adequate plan. And I would say that it is, in anticipating your question of what would we have to offer, the fact is that as legislators and the legislative record, we can bring that information before the DEC.
All right, but again, you've applied for amicus status, so you're not asking or seeking the opportunity to present information through testimony or evidence.
Other than through a brief, yes.
But if you're proposing to provide new information in your brief, that would essentially be trying to provide us with evidence, isn't it? I mean, as an amicus, generally you'd be limited to simply responding to the record as it exists and making arguments about that record.
Yes, and then it may be that we should have applied for full party status, but then again, we are legislators, and that's our primary responsibility.
I'm sorry, what's your primary responsibility?
We're our legislators in Schuyler County.
Right.
We wanted to ensure that the information that we have was brought before this issues conference, but we stopped short of applying for full party status. All
right. Now, with respect to the sufficiency of Schuyler County's plan, that's not really a matter for the department.
Well,
I mean, is it Schuyler County that's responsible for its plan?
Right, but Finger Lakes LPG has submitted an affidavit from our emergency management officer stating that he believes the plan is adequate. So
and that's the 2008 plan?
Apparently so. I'm not really sure. Because
is there a more recent plan?
Well, the draft plan that...
There's a draft plan that
yes.
hasn't been finalized yet.
Right.
And that's one that has been tabled.
Right.
For further consideration.
But my impression was that his affidavit was concerning the draft plan. That these issues have adequately been addressed, because back in 2008, the facility was not even included, as it had not been brought up.
All right, thank you. Okay, you said your
Yes.
co-legislator wanted to speak? All right.
Good afternoon, Your Honor. How much time do I have?
You have 2 minutes.
2 minutes? Okay.
Oh, but you have 2 minutes reserved.
Okay, all right. I am very concerned as a legislator. I've been a legislator for 1 year. I'm a newcomer to the community, having lived here only for about 11 years now, okay? I'm concerned about the impact of this issue on the business of the community, which has been described here already. But I'm more concerned about the collateral effect on the voting, tax-paying, working members of this community on both sides of this issue. I spent two careers responding to and addressing a broad variety of risks, risk mitigation, and human behavior, particularly human behavior that is unacceptable. My concern is focused on the safety and security from the perspective of human error, which we can't predict but can prepare for. And there is a proliferation of safety manuals out there in existence in a variety and spectrum of any industry and government agency in this country. But it's the intentional human action that concerns me. And I have seen that and responded to that over the last 43 years in my 2 careers in federal law enforcement, as well as Director of Global Security for a Fortune 500 company. I am concerned about the vulnerability, the integrity, and the safety of the transportation of LPG, both by truck and by train. In my opinion, my personal opinion, based on those 43 years of responding to those risks and mitigating those risks, I believe that truck transportation poses a low to medium risk, but has a relatively high impact, particularly during race season in this and the height of tourism season. The train issue, the train risk is medium in my opinion, and certainly a very high impact. And an extremely high impact during the race season and tourism season in this county. The races do not occur on just one day, 3 times a summer. It's 2 weeks building up to that, and there's an influx of people, tourists and visitors and fans and all that into this county. That's a primary target, and because of that, the target selection is based on the risk, and it is a low cost, no cost, virtually, to create some type of catastrophe here. I think there has to be safety precautions and risk mitigation focused on the train trestle and the bridge crossing that gorge.
Thank you. You'll have 2 more minutes in the rebuttal. All right, Finger Lakes. Bear with me for a second. I have notes all over the place. So I'll give you 30 minutes.
Okay. In part, my initial comments will be a response to some of the statements made by the petitioners. First of all, Your Honor, we feel that the public safety issues or purported issues raised by the petitioner do not raise a substantive and significant issue. Basically, we're putting the public safety issues into 4 buckets, if you will. I'll call them general safety, risk assessment, emergency preparedness, and rail safety. We do address all these items in the brief. I'm not going to regurgitate that, but I might highlight some of the points that we do raise, and also talk a little bit about some of the comments, as I mentioned, that petitioners make. We start off with risk assessment, because that's really where it started with I think, gas-free Seneca. And they started off talking about how in this case, we have two experts who are disagreeing. Now, we disagree wholeheartedly. We think that there are only two experts who have actually opined with regard to risk assessment, Quest Consultants and William Kennedy. Dr. McKenzie is not one of them. Suggesting that he has any expertise in risk assessment with regard to storage facilities is like suggesting that he is competent to perform brain surgery. And I looked at his CV, and he's not a brain surgeon. So he, we think, is totally unqualified to be an expert on this reported issue. And for that reason, we actually think he should be disqualified from being an expert, and his report should be either dismissed or considered for the weight it deserves, which is actually none. And we mentioned that in our report. So again, this shouldn't be mischaracterized as a disagreement among experts. This should be, the experts are in total agreement here, Quest and Bill Kennedy, with regard to safety. So I'd like to start off by saying that. And
To what extent can I get into expert qualifications to issues conference stage of a proceeding? I mean, we haven't called the experts, we haven't voir dired them. This is like a summary judgment motion. So as long as they're minimally qualified, isn't that all they have to be in order to raise a tribal issue of fact?
well, first of all, we don't think that Dr. McKenzie is even minimally qualified to assess the risks associated with hydrocarbon storage facility or a transportation of hydrocarbon storage or LPG, for example. So we don't even think he's minimally qualified. But, you know, in terms of the offer...
Seneca said that he's got on-the-job qualifications. I believe they said 10 years of experience doing risk assessment and management, so...
For hospitals.
Okay.
Okay, and the kind of risks, for example, that Quest Consultants, twice, by the way, assessed in their QRAs is quite different, particularly given their expertise, than what Dr. McKenzie assessed, quite qualitatively, I might say, and subjectively, in his assessment. And you know, the analogy is attempted to be made between his experience and Mr. Isfan's experience, who has more than 40, I dare say even close to 50 years, I'm not sure how old John actually is at this point, sorry John, of geology and salt formations. To make that analogy is just a preposterous attempt at...
So the only kind of expert that could be heard on this would be one who's had expertise solely in risk assessment for the petroleum industry?
I think that relevant experience in
Under general principles of risk assessment and management that would apply?
There certainly may be general principles of quantitative risk assessment and modeling. That wasn't even done by Dr. McKenzie. I mean, so he didn't even get to that level. I think that the methodology explained in QRA's reports describe the kind of quantitative modeling that really is necessary to determine what the risk is in fact and compare it to other common everyday risks and determine what the risk is with regard to this project, and that wasn't done in Dr. McKenzie's report. So I think that certainly since you know, it's an offer of proof that is made, we disagree with his qualifications, we don't think he's an expert. You can accept his offer and with whatever weight you deem appropriate. We think that it should not be given any weight whatsoever. It's just moving off of some of the comments. First of all, our response does go through quite exhaustively the risk assessment that was done, the safety. There's a complete section on safety in the DSEIS. It's section 4.6, 4.1. We set forth the sections in the DEIS in our written response. So to say that the DS, and in addition to that, and that just talks about safety with regard to the facility, training and the like. In addition to that, there's a whole section with regard to emergency preparedness, emergency response, the ability of emergency responders to be trained and be knowledgeable in the kind of material that will be stored and the kind of risks associated with that. So we think that the record is pretty clear in the DSEIS alone that we've minimized environmental impacts, we've addressed seeker, and to the maximum extent practicable. We certainly evaluated the risk and identify all the mitigation that will be part of the design of the facility. You gonna ask something?
Well, it sounds to me like the folks who might be having to respond with volunteer fire departments and EMTs expressing concern about whether or not they were prepared to respond to the kind of accident that might happen in respect to this facility. Is part of this project going to be to train those EMT and fire persons?
That, yes, and that's set forth right in the DSEIS about the cooperative training. In addition to that, it's set forth in the letter of Dominic Smith, the former fire chief of the Watkins Glen Fire Department, that's hearing document 1D6, attachment 17, and how he talks about the cooperative training. Keep in mind, Your Honor, that this is not the first LPG facility in the town of Reading. We've had historically a facility that was in existence from 1964 to 1984. We've had what was the NICIC facility. Well, we had the TEPCO facility across the street. We actually there's a new facility that was recently permitted, and above ground facility by AmeriGas in the town of Reading. Then you also have the underground natural gas storage facilities as well. So this is not the first time that underground hydrocarbons have been stored underground. So it's really nothing new. And interestingly,
Have they had occasion to have to respond to an emergency?
no.
Thankfully.
But that says a lot, I think.
Although we don't know what the response would be if they did have to respond.
Well, I disagree. I think that the 2008 hazard mitigation plan, and then even though it's just a draft, the draft attached to the petition of the county legislators does kind of describe what that response would be. Now, I will say even though this document being the appendix to the hazard materials plan is just a draft, and apparently it's going through some revisions. What it does reflect, I think, is that currently, today, LPG is transported in Schuyler County by pipeline, by rail, and by truck. And it's been happening for years. And so these are not new potential risks that are just being identified today for the first time. These are things that, and again, Mr. Kennedy, who drafted this document, and this is in the petition, identifies the different manners in which LPG and other kind of hydrocarbons are transported in Schuyler County already, and the potential risks. And he characterizes in his affidavit that risk, and more importantly, as the professional who's responsible for emergency management in the county of Schuyler. Legislators, they're legislators. They're politicians. They're not professional emergency response personnel. Mr. Kennedy is. He's the only one that's qualified to say, along with Mr. Smith, Chief Smith, whether or not the local emergency response personnel are ready to respond to an emergency if in the unlikely event that occurs. Mr. Kennedy talks about, again, and he confirms what I just said, that liquid petroleum gas and natural gas have been stored for years and transported in Schuyler County. He gives his professional opinion, which I think is probably the most relevant in terms of emergency response, that the county government, and you yourself noted that it's the responsibility of the county government to anticipate and address the risks of various activities throughout the county, including risks associated with the storage and transportation of LPG. And he talks about how hazardous materials release in transit was rated at a moderately low hazard level during the 2008 HAZME. That's not inconsistent with the conclusions that Quest has made in their two reports. With regard to the comments made on the QRAs that have been submitted by Quest, I would add a few comments about that. First of all, the frequencies in the Quest report are based on historical data. Storing hydrocarbons, and this is in response to some of the comments that guest Seneca made. Storing hydrocarbons in salt caverns is not significantly more risky than other forms of storage. Mackenzie's risks are qualitative. Dr. Mackenzie's risks are qualitative and based on worst case event only. Quest's QRA is quantitative and compared to certain acceptability criteria. You have to compare risk to something. And that's what Quest did. Now, I will add that, before I go on with some of the comments that were made, the offer of proof made by Mr. Kuprowitz is stated in his affidavit, not as stated by the petitioner. I don't recall which petitioner it is at the moment. The statements made go well beyond.
The Seneca Lakes communities.
Those statements go well beyond what is stated in Mr. Kuprowitz's affidavit. That affidavit represents what his offer of proof is. And what it was stated in the record here in terms of comments about what I believe he will testify to and what I believe he will say. They had an opportunity to put that in his affidavit, and that's not in his affidavit. There's no excuse that there was a shortness of time, because you yourself extended the period of time in which the petitioners could put in and arrange for this affidavit. So a lot of what was stated in the record, and I didn't want to interrupt, goes well beyond what was stated in this affidavit. What this affidavit does is make conclusory comments about things that apparently, some of which are not within Mr. Kuprowitz's expertise. He talks about how salt caverns to safety prevent release of LPG. That's a critical path item. Well, that's not his expertise. That's the next session this afternoon. Okay? He talks about how there hasn't been a risk assessment. Well, apparently at the time he prepared this affidavit, he didn't have a chance to read the 2012 risk assessment or the most recent risk assessment that was presented. I know he didn't have a chance to read the most recent one because this affidavit came before that, but certainly the he should have had an opportunity, and those petitioners should have had an opportunity to provide in that risk assessment. But there's no detailed analysis of that here, and therefore no
Under regulations, that they're only required to give us an offer of proof. They're not necessarily required to give us,
But that's not even done here, Your Honor. Okay. We have to at least see the words of what the offer of proof will be, and those are not here. What you heard was testimony, in fact, by factual testimony by an attorney, not factual testimony of what's based in the record, and therefore, as when you review the transcript, I would ask you to keep that in mind, that those arguments should be ignored. And so the point is that Mr. Kuprowitz certainly does not substantiate his claims that risk is not being properly addressed. Low probability events were actually included in the Quest QRA. And chain of events risk is not a proper way to evaluate risk according to Quest and its QRA. In our opinion, the facility is not capable of physically damaging the wineries. They're simply too far away. The closest winery in the list of those who have submitted affidavits on behalf of the Wineries Business Coalition is as driving distance 3.4 miles. And the furthest is over 40 miles, I believe. So this notion of a zone of interest, I don't know exactly where they're going with that, but if they're trying to argue that that's some kind of akin to standing, then certainly the case law would support the conclusion that 40 miles does not place someone within the zone of interest. In terms of the suggestion that LPG consequences and risks have not been taken into account, well, of course they have, because it already exists in the region, and we've shown that. Including up, I mean, not that I'm suggesting that this should be the zone of interest, but even up north on Route 14, as you get closer to Geneva, there are LPG facilities and distributors, large ones, in fact, who are supporters of the project.
well, rail accidents involving petroleum products are not unknown. Is it a consideration given this trestle going across the chasm?
You know, I've visited Watkins Glen State Park and enjoy it, but I know that train trestle is there for a reason. and that is for trains to transport goods and products. And those trains have been doing that for years and years. NS has been controlling that operation since 1999, I believe. And
If a train was to derail at that location, though, I mean, was that specifically looked at all in this risk assessment?
I believe that was, Your Honor. I believe it was in Mr. Kennedy's analysis. And the Quest Transportation QRA. And also, and particularly in the context of the response from Quest to Dr. McKenzie's so-called qualitative risk assessment. That's towards the end of the QRA report that we do address that and the potential consequences of that. But Your Honor, the fact is, based on the record and based on statistics, that you're talking about 99.9977 of all hazardous materials shipments reach their destination without a release caused by a train accident. And that's pretty telling. And in addition to that, Norfolk Southern and the DSEIS explain the level of inspection that they conduct and on their own, and also as required by federal regulation. The rail companies are regulated by the Surface Transportation Board, the Federal Railroad Administration. We've argued in our brief about how exactly how those operations are conducted is preempted under federal circuit case law.
I understand, but, I mean, wasn't there a train derailment in West Virginia recently? I mean, so it does happen. And again, I guess my main question was it considered that if such a derailment were to occur, for example, at this trestle, is there going to be an adequate response?
And the answer is yes.
And that's been studied.
To both questions.
And I can find the results of that in the Kennedy analysis and in the Quest volume review.
Yes. But again, I don't want to gloss over the fact of statistics. Now, while the press may put on the front page very rare instances where you see that occurring in West Virginia or wherever state, the fact is that the safety record of the rail industry speaks for itself. It's not just the rail industry telling you what their safety record is.
Well, that's why it's a low risk, though. But if there's a high potential harm to result in the unfortunate circumstance that rail safety fails, then we want to know there's a sufficient response.
And there is.
Right? And I can find that in these documents.
Oh, absolutely. Yep. And again, I mean, this is not something that's new. I mean, this is something that has been known for a long time, and so as Mr. Kennedy explains in his affidavit, I mean, it's his professional opinion that the county is prepared to respond to any potential release, whether it's LPG or any other kind of hazardous material that may be used, at other locations in the county. And there are other industrial facilities in the county where that could occur, and where hazardous materials are stored.
By pipeline considered to be safer?
Well, I think that they're both safe, to answer your question a little bit differently than how it was asked. I will say, however, that since you bring up the issue, that pipelines are also regulated by the federal government. And to suggest for some reason, and it sounds like, that pipelines aren't safe and therefore should be shut down would suggest that the existing pipelines, and there's miles and miles of existing pipeline currently in this county, as reflected in the document that the county legislature submitted, suggests that those pipelines should be shut down, which is a preposterous suggestion. Now, they may not be suggesting that, but that's how I heard it. But rail safety is regular. Pipelines are regulated by the Pipeline and Hazardous Materials Safety Administration, which is an arm of the US DOT. There are specific regulations with regard to pipeline safety under 49 CFR Part 192. So there are very stringent regulations, and those regulations have been adopted by state agencies as well. So rail safety, we're not just relying on the fact that, okay, the feds have jurisdiction here. what we're relying on is the safety record. We're relying on really the fact that it already exists today. And I think the record reflects the fact that there is not, in terms of the project and what it adds to rail, at most maybe one trip per day, but that's it. Otherwise, I mean, there are rail cars going over that bridge today that have hazardous materials in them, and there has not been a problem, and that's because that the track is inspected twice, I think twice weekly, and then the bridge is inspected annually. So there's a good record there, and so I believe I'm almost done. I would also say that a couple other points. You asked about amicus status, and I think you asked a couple of the petitioners about this, and what does it mean to them? I'm paraphrasing you, and what would they bring? And part of the response I heard from the county legislators was that, well, maybe we should ask for full party status. Well, they didn't ask for full party status, but what I also heard, by the way, was information, again, factual information that goes above and beyond what is written in their petition for party status. Unsubstantiated.
Can we take that in, though, as comments on the EIS?
Yes. Frankly, I think comments that have already been responded to by what's in the record. But perhaps they haven't reviewed all of the records to look at, what their county emergency manager has said, what the fire chief has said, what we have said in the DEC, and that is that we've addressed these concerns that are in the record. You can certainly take it in as comment. Again, some of their comments were, again, unsubstantiated facts that they presented. They had certainly had the opportunity. So I don't mind taking a comment, but if there are facts that are being offered as fact, but without any substantiation, any documentation, this was the time to do it. Actually,
well,
January.
The significant point, though, is that we have the 2008 plan, that the current one is only a draft, and in fact, that's being further considered. Isn't that important to know, particularly if we're relying on the local response? Is it important to know what the status of the local plan is? Can I kind of accept that? Can I take official notice of that?
I think you can. That's not really what I was talking about. There were other comments about WGI, for example, being the number two terrorism target outside New York City. Where's substantiation for that? There were other facts. The status of the plan, that's something else. But as you parse through the transcript, you will see with their testimony and others who have testified, it goes well beyond what has been set forth in the petitions for party status, which was their opportunity. This is not the opportunity to supplement the office of proof, maybe explain, maybe to characterize, but not go beyond, in essence, what they had an opportunity to do to begin with. And, Your Honor, in terms of the 2008 plan, that was referenced, but it's not in the record. I have a copy of it if you want to add that to the record.
Or you are the record?
It's not. It was not. No, the addendum, the appendix, the draft appendix was, but not the existing plan. Now you can take judicial notice of it, or I actually have copies of it, so you can mark it, whatever you want to do.
Sure, I'll take it in.
I have extra copies, by the way, as well.
So, yeah, that'd probably be good if we gave
During a break. But again, it's an official document. It's something that I've created. It was right off their website. But I thought for the completeness of the record, it was important to get that in. Going back to my point about amicus status, the regulations say under 624.5B3 that additional content required for petitions for amicus status is to provide a statement explaining why the proposed party is in a special position with respect to that issue. The issue that's being proposed here is public safety. You asked, I think, Ms. Torr, a question about that, about amicus status, not necessarily focusing on that part of the regulation, but I'd like to focus on it because I don't think that there's anything in their petition that necessarily reflects a special position with respect to safety. Now, it's more of a economics and business perspective. And maybe generally they talk about safety, but they're not in any particular special position because of any expertise or knowledge to present beyond what's already been presented in the petition. So I would disagree with the statements made earlier by Ms. Tour in that regard. So I'd like to just come back a couple other items, Your Honor. I think that in addition to Mr. Kennedy's affidavit in the record, we do have letters in the record by the designer of the surface part of the facility, Superior Energy, in their hearing documents 1B6, 14, and 16. And then National Fire Protection Association Code 58 is also included in the record as 1B6, attachment 15. And the purpose of me mentioning these letters simply is to demonstrate that the designer of the facility, someone here, Mr. Young, who's actually in attendance, or was, I'm not sure if he's still here, has over 50 years designing LPG facilities, knows what the safety and design standards are, and describes them in his letters, which are dated October 31st and December 8, 2001. And as well, the NFPA 58, which relates to which was prepared by the Liquefied Petroleum Code Committee of the NFPA, addresses how these facilities, particularly the surface aspect of the facilities, should be safely designed. Just going back to, finally, and I think my time's probably running out, I'd like to go back where I started. Scientific formulations, which is required. You need to have experience regarding underground storage facilities, geology to provide as a scientific foundation for these risks. You don't necessarily need experience in petroleum, but you have to have a foundation. In science, with regard to the kind of material stored, he does not. So he fails as an expert for lack of a scientific foundation. So, going back to the 4 buckets, to conclude, there are 4 buckets of public safety. One is risk assessment. There were 3 quantitative risk assessments done, 2 by Quest and 1 by Mr. Kennedy. And they all show that, in their opinion, that the risk is low. We had a DSEIS and other letters in the record that support the kind of safety measures that will be taken with regard to the facility and the design of the facility and the emergency release prevention and preparedness policies that would be in place. By the way, that's supplemented by the DEC permit, which has a very lengthy condition with regard to safety and emergency shutdown devices. I'm sure the department can respond to comments made criticizing them for that and their ability to determine whether or not such a plan is sufficient. But we've certainly shown, and we're the only party to show, through letters and affidavits, through documents, through references in the DSEIS, that in fact, those who are trained and responsible to respond to potential emergencies know the properties of LPG, have been trained in such through their experience over the last however many years, probably 50 years, and know how to respond and have the personnel and facilities to do so. And finally, with regard to train safety, I would say that the record speaks for itself in terms of the statistics. Statistics don't lie, and I think that much has been made in the petitions, and it's to us all speculation, all melodrama, frankly, not based on any fact. And so on the one hand, you have speculation and melodrama not based on fact. On the other hand, you have scientific quantitative risk assessments, statistics, federal regulation, and the mitigation and safety controls that will be in place to make sure that this facility is designed safely and it's operated safely, and no matter which way the material is transported, it's done in a safe way. But in the unlikely event of any kind of event, as low as that might be, that there are trained emergency responders in place who are working with our facility and the TEPCO facility across the street and the AmeriGas facility in the other part of Reading to know the properties of LPG and how to control it. So thank you.
All right, so, department?
All right, it's Lisa Schwartz again. I'm going to make a few points, and then I'm going to pass the baton to Jen Maglianti on the issue of public safety. I'd like to start out by saying that it's department staff's position that there is no substantive and significant issue related to public safety regarding this project, and therefore there's no... I'm sorry, I forget I'm short. Should I say that again? Okay. I'd like to start out by saying staff's position is that there's no substantive and significant issue related to public safety regarding this project, therefore the same being that there's no adjudicable issue related to public safety. Now I'd like to just highlight for you about the applicant's original QRA, the first one in 2012, which made quantitative assessment of the risks associated with the release of LPG, which we found to be at that point an appropriate scope for it, and still do. The staff reviewed the submission, inquired of the applicant. There was a conference call. There was a follow-up letter. Let me give you the sites in case you want to go back and look at some of this record. The actual QRA is at document list Roman numeral 1B8 and also 1B7 Exhibit 1. And the follow-up letter.
It's the same thing. both
Yeah, we
places.
put it, it just ended up in two places.
All right.
And then there was a follow-up letter after our conversation, I think it was a conference call, with Quest and the applicant, Quest being the consultant that wrote the 2012 QRA. And that follow-up letter is at document list IB13.
I'm sorry,
Roman numeral I, B13.
13.
Which at that point was a response to a department letter prior in the document list, and I'm sorry I don't have the site for you there, but it's in order. I want to note first about that QRA that the DEIS had already addressed safety impacts, so this was in addition. And in addition to saying that the department staff found the QRA acceptable, I believe that I also have to say that a QRA in and of itself, and this one in particular, did go beyond the level of evaluation in this area that's typically required by the department. So we think that should be noted. In particular about this QRA, we think it's important to note that it concludes the hazards and risks associated with the facility, the proposed facility, are similar to those presented by LPG transport, storage, and processing facilities worldwide. And while the off-site risk of the LPG associated with the operation of the LPG facility isn't quite zero, the off-site areas that impacted by higher risk levels, that isn't to say impacted by some event, but impacted by the higher risk level, are limited to a few uninhabited locations. I think that's important. And most off-site areas are found to be impacted with relatively low levels of risk. In addition, the consultant preparing the QRA noted its analysis is conservative in nature, so it should provide an prediction of the true risk posed by the facility. Those are the things we thought should be noted about it. We haven't heard it discussed much yet here today. And I'd like to give my time now to Ms. Maglianti.
Good afternoon, Your Honor. So Ms. Schwartz talked a little bit about what was in the DSAIS and what was in the QRA, and I want to spend a couple minutes and talk about what was in the petitions for party status, because Because as you know, the standard here is that the burden of persuasion is on the petitioners to prove that there is some omission in the application that's worthy of consideration and for detailed litigation. There's two affidavits we want to talk about specifically. One is the affidavit of Richard Kuperwitz. Mr. Bernstein talked about that generally. Mr. Kuperwitz's background is in pipelines, but he offers here an opinion about the relative safety of this project. And one of the conclusions he comes to is that LPG is less safe than natural gas, and that it poses greater risk than above-ground storage. Of course, when you look at the application, the department here isn't weighing the alternatives of either above-ground storage or an alternative fuel for storage. We're actually looking at alternatives to the proposed projects that's within the constraints of the applicant's ability to change. So in some ways, Mr. Kuperwitz's opinion is irrelevant to the consideration of relative risk. The other thing that Mr. Kuperwitz talks about is opinion about local responders. And ultimately what his conclusion is that, well, it's not likely that local emergency response is going to be able to effectively handle any kind of accident at the facility. The problem, as Mr. Bernstein pointed out, is that there is actually no detailed analysis in the affidavit. What he offers is a mere conclusion. Well, it's likely that they're not going to be able to handle an accident at this location. Of course, that's a mere conclusory statement. There's no literature references in his offer of proof, and there's no citations to available literature, and there's no analysis of his own. Now you look at that in contrast to what we have in the DSAIS. We actually have an analysis of local resources and their capability of response. So as a matter of fact, their offer of proof fails to raise an issue because it doesn't even give enough detail for the department to actually respond to it. As you know, the regulation is at 624.5B2, and there it states that the offer of proof has to actually identify what evidence is intended to be presented by the petitioner and the basis of their opinion. And in the case of Mr. Kuperwitz, they've done none of that. It's important and noteworthy to indicate that the memorandum of law that was submitted by NRDC used words like perhaps, maybe, Dr. Kuperwitz, will maybe testify to this. We do not go to costly adjudication on perhaps and maybe. It is important for expert opinions to offer detailed analysis of their own to refute what's in the application materials. Mr. Kuperwitz's affidavit doesn't do any of that. And as Mr. Bernstein indicated, Ms. Sinding actually got up in her presentation and said that Mr. Kuperwitz will testify that the QRA is deficient. That's interesting because his actual offer of proof in paragraph 13 of his affidavit says that I understand that others who have had more full time to fully consider the applicant's risk assessment have concluded that it is extremely deficient in this critical regard. So really, what we have is Mr. Kuperwitz relying on somebody else's unnamed opinion of risk assessment. So in fact, despite what Ms. Sinding said to you, the offer of proof didn't indicate that he had an opinion about risk assessment. He just said, well, relative to other types of facility, there's a higher risk of LPG storage. So what department staff submit is that they failed to meet the burden of persuasion on that issue. Now, they also offered the opinion of Mark Venuti from the City of Geneva, who's the supervisor for the City of Geneva, and he made some statements about public safety as well, and that there might be an issue if the City of Geneva has to respond or serve as backup to another fire company that has to respond to Watkins Glen. And again, we don't have analysis here, we just have a general statement, and we can take that as public comment, and we can address that in our FSEIS, but there's certainly no obligation for us to have an opinion or a conclusory opinion offered up as a matter for adjudication. So that takes us to Dr. McKenzie. It certainly doesn't give department staff pleasure to do this, but we have to agree with the applicant. There's nothing in Dr. McKenzie's background to suggest that he's actually competent to testify in risk assessments in underground gas storage. Now, you talked to Mr. Bernstein a little bit about what's the standard that you apply. How far can we go in an issues conference? Well, I have the answer for you. So at an issues conference, what we say, and I can give you some citations, it's matter of application of matter of mine. It's an October 26, 2012 issues ruling. And there it said that the qualifications of the expert witness that a petitioner identifies may be subject to consideration at this stage. And what is it that we need to look at? And so there's another administrative case that says that at the issues conference, it should be enough that the witness is competent and willing to testify. So how do we judge competency? So the way that we judge competency is that we actually... That's Granite Asphalt Products Incorporated. It's a March 3rd, 1994 issues ruling. Asphalt. So how do we judge competency? So we judge competency by looking at the expert witness and saying, do they possess the requisite skill, training, education, knowledge, and experience from which it can be assumed that the opinion rendered is reliable. And that is actually a citation to a matter of Inu v. Sobel, and it's a 208, 82nd, 1123. It's a 3rd Department 1994 case.
I'm sorry, what was the 80 site?
208, 82nd, 1123.
1113.
1123. Sorry. Well, the interesting thing about that case, it was actually an Article 78 proceeding to challenge a physician's disciplinary case. And there, the challenge was, is a general practitioner qualified to judge the qualifications of a urologist? Well, here you actually have two people that went to medical school, and there was a dispute about the level of expertise that was needed. Here we have a medical doctor talking about risk assessments in underground gas storage operations. There's certainly nothing in a CV to indicate that he's experienced in pipelines, that he has experience in transportation. And the degree of expertise that he needs is reflective of the material that he's presenting. He's presenting information that is highly complex and highly technical, and he makes summary conclusions about it without any expertise or education in this field. So let's talk about a little about what he actually said in his affidavit. So one of the things that Dr. McKenzie does is, and it's a little hard to follow because in a lot of ways his analysis was unclear. He sort of puts this matrix in there to say that, well, there's a high risk, high impact, low impact. But there's no actual explanation in there as how we actually assigned specific types of operations at this facility to that matrix. And it's important to note that as an offer of proof, he also just said, well, I'm not actually an expertise in salt cavities, I'm not an expertise in integrity, but nevertheless, I'm going to make judgments about integrity and advise my party that we should deny the permit. So again, he assigns this matrix. It's nice. It's a nice color-coded chart, but he doesn't give any indication of how he assigned specific values. So it's hard to follow the methodology.
Wouldn't that be done at a hearing? I mean,
It would be done at a hearing.
How far do we have to go? That you're only required to have an offer of proof, so it doesn't have to be the full
Right.
showing.
It doesn't have to be the full showing, but what it has to do is it has to demonstrate that we actually can understand the basis of opinion. The offer of proof specifically says, provide the basis of your opinion. What he did was, he just offered the conclusion. Well, if there's this type of accidents, I conclude it's this. It's a matter of opinion, but he has to offer more than just that. They just have to explain. We certainly don't want full testimony on this because we disagree with his qualifications. But certainly we have to have more to understand how would you actually apply this. There's certainly nothing in the field of risk assessment that would suggest that you just arbitrarily assign these values. One of the other problems that I know it's sort of hinted on in oral arguments today is incremental risk. I mean, we do talk about the existing industrial activities in this area. We do have the TEPCO facility across the street, which is an LPG storage facility. We have a natural gas storage facility sited just to the south of Finger Lakes. So Dr. McKenzie sort of introduces this concept, and he asks the question right up front in his risk analysis, what's the incremental risk associated with this facility? But then he never actually answered the question. So it's difficult to say what his opinion might be since he never evaluated, well, what is the actual existing industrial character of this area and what risks are present in the community right now on which to compare the impacts of Finger Lakes. So it's difficult to say where his analysis come from. There's also a 100-year history of solution mining in this area that continues today.
But this isn't solution mining.
No, it's not. No, it's not. But there are risks associated with that. I mean, you're talking about pressuring cabins. It is an industrial activity, and it is something that should be considered. There are other activities at U.S. Salt that go on there that should be part of the consideration of what happens in this particular area of the state. His analysis doesn't consider any of that. To wrap up Dr. McKenzie, we dispute his qualifications, but we also dispute his methodology. There's certain key points that he failed to include in his analysis. And when you look at that in comparison of what's in the DSAS and in the analysis done by the applicant, here we actually have 113 different operating scenarios reviewed. We have zone of impact analysis, we have rail car analysis, truck accident analysis. So there's a lot of detail in what was presented by the applicant that certainly rebuts anything that was put in the petition's party status. The other point that when Ms. Sinning was up here is she said that, going back to Dr. Kuprowicz, that he introduced the concept that of low probability and high risk events. And what she said was, I believe he'll be able to speak on what mitigations are available. And of course, that speaks to the level of specificity that was in their offer of proof. And on public safety in general, the applicant talked about this a little bit. There is detailed information in the draft and permit conditions, as well as the draft SEIS, that speak to public safety. Mr. Bernstein referenced the National Fire Protection Association. It requires redundant measures. There are shutdown mechanisms that can be put into place. The draft permit conditions includes a detailed list of requirements that has to be in the emergency response plan. We gave absolute due consideration to public safety in this, and no subsequent issues have been raised by petitioners. That's it. If you have any questions.
Going across the trestle and derail.
We did. Yeah. It is something that is disclosed. I mean, we talked about. We can talk about that in our briefs more fully. But we do consider, and it's okay for a state agency to disclose those types of impacts. And the applicant did evaluate, okay, what is the level of incidence, or how can we quantify the risk posed by trail accidents? And they also have detailed charts, and they're talking about, well, here's a puncture or a major release. They talked about not only the type of accident, but the scope of that accident, because not all accidents are going to be the same. Not all accidents are going to have, high release event. So that information is in there. It's in their quantitative risk assessment, and it was addressed.
People are concerned with is there an adequate response? Was the response,
Right.
whether that would be adequate,
Right.
analyzed by the department?
Right, and the department made an elaboration in our DSAS. We did what we could. There's outreach, there's still local training involved, and obviously the local emergency responders have experience with the TEPCO facility and the natural gas facility, so they do have the means available to them to respond to an accident. And to get to the preemption issue, I mean, we certainly can detail the legal precedent involved there, but certainly a state agency can disclose impacts, but we are not with the ability to mitigate them. As soon as that train leaves the station, so to speak, we do not have the ability to either, as the petitioner suggests, ban trains, limit trains, or regulate them. We certainly can discuss impacts, and as far as other community character type impacts like noise, we can certainly do things at the site to try to mitigate the noise that might be experienced from rail siding, but we are not allowed to decide how articles of interstate commerce move across the state.
Seeker wouldn't allow us to
Seeker
ban
would not allow
trains
us. No, it would not.
if there's an unacceptable
No, it
environmental
would
impact.
not. We're absolutely federal, absolutely. Yep, not only through the Surface Transportation Board, because the pipeline, and also the pipeline, there's also a contention there that, well, pipelines present a safety risk. Well, the Pipeline Hazardous Materials and Transportation Act speaks to federal jurisdiction over pipeline safety. So has been adequately covered.
But we
And
could mitigate by imposing stricter requirements in terms of, say, training the locals or providing them with funds or
certainly,
something like that, right?
certainly, those are within our control.
Right.
But as far as limiting the amount of trains or limiting the amount of movement through pipeline, that is a matter strictly within the federal domain. Right? Thank you.
Thank you. All right, we have some rebuttal time reserved. Start with Councilor Seneca. I have 5 minutes for you. Do you want me to set this for 4 minutes, or do you want me to set it for 5?
4 would be fantastic. Thank you, Your Honor. I want to start by just clearing up a few things. First of all, Gas for Seneca is not arguing that somehow the DEC has any kind of authority to ban trains or stop
That might have been my
pipelines.
idea, so.
Well, no, I think actually the applicant might have raised the issue of shutting down pipelines. That's not what we're suggesting. What we're suggesting here is that in evaluating and approving this project, if the DEC determines that the risk posed by trains or pipelines is too great, the remedy is not to approve the project. That is what SEQR requires you to do, is assess the entirety of the project's adverse impacts, and if you can't mitigate them because of federal preemption or any other reason, then you don't allow the project to go forward.
Well, we do a balancing at that point. If we find there's unmitigated environmental impacts, then we balance
Yes,
those
and
impacts against the socioeconomic considerations.
Yes, but ultimately, if you do conclude that the risk is just so great that it does outweigh everything else, your remedy is you do not allow the project to go forward.
So you're relying on lane.
And pardon me?
You're relying on lane.
I'm not familiar with that, Your Honor.
That's the case where the unmitigated impacts outweigh the socioeconomic.
Then, yes, I am relying on that. Thank you, Your Honor. I also want to point out that a lot of the statements by the applicant is that this is perfectly safe and that there is no higher rate of accidents in salt caverns, and when you use salt caverns for storage of LPG, and that just from a standpoint of historical data is inaccurate. There is a much higher incidence of accidents associated with storing LPG in salt caverns than there are in other kinds of underground facilities like depleted.
I thought what council was saying was that with respect to transport, I don't think we've talked about.
He did
cavern
mention
integrity
the cavern
yet.
integrity issue as well, Your Honor. With
Okay.
respect to
Well,
transport.
we're going to have a whole afternoon on
Yes,
that,
and I
so-
don't want to bog us down in that at all. I'd also just like to go to the question of the Kennedy affidavit and whether or not any of the submissions by the applicant have addressed specifically a potential for accident at the rail trestle. And the answer is no, there's nothing in this affidavit that specifically addresses that. What Kennedy actually does is discuss the plan that Mr. Bernstein handed to you, but then continues on to suggest in paragraphs 4, 5, and 6, stating that in each instance, the plan indicates that serious injury or death is likely to large numbers are anticipated outcomes of uncontrolled releases. Kennedy then moves on to talk about the process that is being undertaken in Schuyler County of updating the 2008 plan, which strongly suggests that the 2008 plan might not be adequate to deal with these sorts of incidents. I also want to, in the time I have, address the question of Dr. McKenzie's qualifications again, and to point out that if we are quibbling about whether 10 years of experience versus 50 years of experience is what meets the standard, I think that's exactly the type of inquiry that is more appropriate for an adjudicatory hearing. Meanwhile, Dr. McKenzie does have experience developing comprehensive emergency management. He is not merely a medical doctor. He is also the CEO of a hospital, and in that capacity, he has gained significant experience with respect to risk assessment. And risk analysis, rather. There is a difference, actually. And in that role, he's collaborated closely with emergency management personnel and even supervised some of them. So to completely discredit that and say he has no experience and focus solely on his medical degree does not give him the due consideration that he warrants in this situation. There's also some question raised about his methodology and the fact that there is no explanation of his methodology in his report. And in fact, he does describe how hazard events are scored using a methodology employed by the Marcogas European Underground Gas Storage Study Database. And he in fact includes an entire appendices to his report entitled Methodology. So to say that he doesn't explain his methodology and to try to discredit him on that ground is really not accurate either. In conclusion, Your Honor, I think there are many issues here many issues that we have raised in Dr. McKenzie's report that do demonstrate that there are disputed issues of fact here. And the only appropriate action at this point is to push this off into adjudicatory hearing for those issues of fact to be more fully discussed and elaborated on. Thank you so much.
Thank you. So, Finger Lakes Communities. You have 3 minutes. I'm going to set this for 2.
Your Honor, I asked for 3 minutes, but given that there was some rather outrageous mischaracterizations made of what both I and Mr. Cooperwitz said, I'd ask if I could have 1 additional minute, particularly since I didn't take all my time in the initial presentation and Mr. Bernstein was allowed to go rather beyond his allotted time.
So we're talking 4 minutes?
That would be great. Thank you, and I'll try and go through it quickly.
I'm going to set this for 3.
Thank you, Your Honor. So I first want to respond to Mr. Bernstein's contention that statements that I made in my presentation go beyond Mr. Cooperwitz's affidavit and venture into factual argument. They do not. They merely clarify and explain that which Mr. Cooperwitz says in his affidavit. DEC argues that what Mr. Cooperwitz said is in paragraph 13, that he's relying on what others' assessment of the risks from cavern integrity are. That's not true. What Mr. Kuprowicz says is in paragraph 9, and I'll read it. I conclude that the proposed Finger Lakes LPG storage facility has not provided adequate or appropriate risk assessments related to this highly unique proposed LPG storage and/or transportation infrastructure project. That's his conclusion, and that's what he would testify to. Secondly, nothing I said in my presentation constitutes factual argument or testimony, even if you put quotations around it. It was an offer of proof, and I'm confident that when you review the record, that will confirm that. To be clear, what I said was merely an elaboration on the methodology Mr. Kuprowicz believes should have been, but as Mr. Bernstein expressly conceded, was not utilized in this case, which is a chain of events methodology. Third, regarding the history of storage of hydrocarbons in this area, something Mr. Bernstein spent a lot of time on, I will read what Mr. Kuprowicz would say to that, so that there's no question whether it's what I'm saying or Mr. Kuprowicz says, and that's paragraphs 10 through 12 of his affidavit. The safety risks of storing up to 2.1 million barrels of liquefied petroleum gas in underground salt caverns are substantially different and orders of magnitude greater than those associated with the storage of high-pressure natural gas in the same underground salt caverns. The consequences of a release of highly volatile liquids, such as LPG, would be significantly greater than those associated with a release from a natural gas storage facility. Storage of LPG in underground salt caverns presents much greater safety risks than those associated with LPG storage in above-ground facilities or those associated with LPG transportation. That is not a discussion of alternatives, as Ms. Maglianti seems to suggest. That is a direct refutation of the applicant's reliance on the history of storage of other kinds of hydrocarbons in other kinds of facilities within the region and the adequacy of the region's ability to respond to emergencies from those inapposite types of facilities. Fourth, as to the claim that Mr. Kuprowitz's affidavit is in insufficient offer of proof, Ms. Maglianti says that there's a lack of citation to available literature. Then she cites to the regulations. There's nothing in the regulations that requires the citation to available literature. In fact, the first 2 pages of Mr. Kuprowitz's affidavit lay out in detail his extensive experience and expertise in these issues. That's the basis on which he would offer his testimony. And we submit that together, the offer of proof that's contained in the testimony, as further explained by me today, or on the basis merely of what's on the paper, together with his qualifications, satisfies the requirements of the regulations. Fifth, DEC argues that Kuprowicz doesn't conclude that the QRA is inadequate. Again, that's belied by the actual language of Mr. Kuprowitz's affidavit, which I read to you at the outset. And finally, as to the contention that NRDC's petition contains words such as maybe or perhaps, the 2 pages in the petition that refer to Mr. Kuprowicz and his testimony and the offer of proof that we put forward are pages 19 and 24. Nowhere on either of those 2 pages does the word maybe, the word perhaps, or any recognized synonym of those words appear. Thank you.
Thank you. Finger Lakes wine business, 4 minutes.
Again, Your Honor, we would like to respond to some of the statements that were made concerning our presentation and concerning the interest of my clients. There has been repeated assertions that none of the wineries are within any proximity to this facility. The map that we've referred to as Exhibit B does detail the wineries, and we would submit they are throughout the region, along the shores of Seneca Lake as well as the adjoining area. However, the Castle Grish winery is within a quarter mile from the facility, and they have actually, as set forth in the affidavit, purchased property that adjoins the facility. So we would submit that they are indeed impacted directly and within the region itself. We would submit that those are concerns that need to be taken into consideration in terms of an emergency response plan. And in fact, I believe that the information that has been presented to you by Mr. Kuprowitz's affidavit and other proof demonstrates that there could be a catastrophic event from this facility no one has really discussed what a catastrophic event means in this context and this facility. A catastrophic event could have wide-reaching implications. We have no idea how far, if there were any kind of an explosion or a spread of gas, the impacts of such a catastrophic event would be. In terms of emergency planning, we would need to analyze exactly what a catastrophic event would do. My clients and the agricultural interest that they assert could be very much impacted by such a catastrophic event, the spread of any kind of an explosion, the damage from fire or the spread of gas to the natural environment has not been assessed. All of that is why we feel as an amicus we should be granted status. We believe that the agricultural issues here, the agricultural perspective here on safety is a very valuable and unique perspective that the wineries and the businesses surrounding them can present for your consideration as you look at these issues. We think that the experts that have addressed these issues have not addressed the agricultural issues, and in fact that the risk assessment has not in fact addressed the agricultural issues. The cumulative impacts of these facilities and the cumulative impacts of any incidents that occur have also not been considered in an agricultural context, whether or not there is seepage of any gas from the facility, whether or not there is a slow deterioration in water quality. Those issues have not been considered in terms of the public impact, the safety impact, and the impact to the agricultural community. We have a letter from the fire chief that says, that they may be adequate to address what happens in these incidents. There's no indication that anyone consulted with any of the agriculture in the area to determine what their needs are in an emergency response facility, whether or not they would need some special address to their concerns. There's also a determination that we don't have enough of an impact upon my clients for us to speak to this particular issue. I would also submit that Route 14 that runs up along the facility is regularly traveled by the tourists that we bring to this community, and that would impact upon their safety and my clients' interests in the community. Again, we would submit that there has not been adequate consideration. We don't believe that this is melodrama. We believe that the very dramatic impacts of public safety need to be adequately considered. In looking at the fracking issue, the Department of Health, the commissioner spoke to the health impacts and said he wouldn't want his family next to such a facility. My clients and their businesses don't want their tourists and their businesses next to this facility. So we would submit that those considerations and the safety considerations and that perspective is of value to you in evaluating these issues.
Thank you. Let's see, so legislators, we have 2 minutes.
Thank you again, Your Honor. I would like to note that William Kennedy, that submitted this affidavit, is an employee of Schuyler County, number one. He is the supervisor, manager of the emergency response effort for the county. In his affidavit on page 3, second line from the bottom, I believe Mr. Bernstein misquoted that. And we have not seen this affidavit in our role as the legislators until this meeting. But I think he has flip-flopped the characterization of the hazards at the bridge, hazardous materials in transit, and particularly at the bridge. In 2015, he downgraded it to a low hazard from a moderately high hazard in 2008, the last time the emergency plan had been revised. We do not know the reason for that re-evaluation, if you will. As legislators, we do have the oversight responsibility, so we've not seen this, and there are a number of gaps, but it's difficult to maintain currency with the changes in technology and the threats. in today's world, as you see going on around the world. And for the most dangerous combination of 4 words that I can think of are, "It won't happen here." That's what they said in '93. That's what they said on September 10th of 2001 down in New York City. And I know also during a recent hearing of the county legislature.
That's your time, so.
Okay, may I have, okay, direct question to the chief law enforcement officer of the county. Is there any security technology monitoring devices at all at that bridge? There are none. I would be much more comfortable and maybe not as strident if there was some security afforded that location. Thank you.
Thank you. All right, I believe that concludes the public safety issue. While we're here, did everyone get a copy who wants one of the May 2008 Schuyler County Hazards Mitigation Plan? That was handed out. I'm going to be marking that as Issues Conference Exhibit 00031. So I guess we'll adjourn now for half an hour for lunch. Is that going to be enough time for everyone, or do you want longer or less? Let's go off the record just a moment.
Your Honor, we have to drive to get, I mean, most of the room is not going to be able to eat. And I'm sure nobody brought, all their food with them.
I did.
I think we need an hour.
An hour? Because I think, let's see, I was planning on starting at 1:30, which would be getting us done at 4:30. So if we put it off an hour, that would be getting done at 5:30. Is that going to be a problem for everyone or anyone? For the court reporter, who's the most major concern? All right, so let's go back on the record. So we're going to adjourn then for 1 hour for lunch. So let's please, everyone who's involved in the confidential session, please be back by 2:30. Those members of the public and press who aren't signatories or of a confidentiality agreement will have to ask you to leave the hearing room. You are free to come back tomorrow morning at 9 o'clock when we will be resuming the public portion of this proceeding. Unless there's anything else right now, we stand adjourned. It'll be 00031. You have the chart, right?